references. I just asked you to reply on point of law.
It is, my lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
My lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Opera is okay. Where are the others? Ejiofor, where are the others? Yes, you just have 2 minutes for this. Yes.
I'm most grateful. Once again, I will start with the bail application that I made. Since he did not file any counter affidavit, my lord, he is in effect conceding. And I expect that this very application should be determined based on the affidavit that I filed.
You may sit down.
And on the issue of stay, my lord, once a matter borders on jurisdiction, stay can be granted.
Op zoek naar meubels die jouw stijl weerspiegelen? Bij Feelings Wonen vind je...
The appeal court for the determination of these very key issues, and also I reiterate that AJA is not superior. It is not superior to the Constitution of this very country, and an established jurisprudence as determined by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. And my lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C45, my lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't even exist, my lord? It doesn't.
You are exceeding the 2 minutes.
Okay.
Just
yes, please. I ask my lord that I be granted bail on very favorable terms, given that a concurring judgment of the Supreme Court of Nigeria determined, my lord, and found that I did not judge bail. I never did. That was their finding. I did not judge bail. And that the revocation of my bail implied that.
It's okay.
Thank you, my lord.
Thank you.
That's it.
You may sit down. On the 12th day of November 2025, seeking for 2 reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The second relief is an order staying further proceedings in the charge, pending the determination of the questions by this court to Court of Appeal. The third motion has to do with the notification to file written address. As defendant stated, he has put in his defense as his right to file written address should not be taken away from him. I've considered also the processes filed by the prosecution in reaction to some of the motions. In the application seeking to refer some questions to the Court of Appeal, the defendant submitted inter alia that the court cannot proceed to give judgment on a defective charge not founded on a written law, and that the court cannot rule on count 7 of the charge, contrary to the decision of the Supreme Court. I must say, most of the issues raised here in the application, save the application for bail, have been raised by the defendants severally in this court. And this court has made an order that all preliminary objections or issue shall be taken during the judgments. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings the statutory law governing criminal procedure in Nigeria, 2 weeks. Administration of Criminal Justice Act 2015. By Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. These statutory provisions was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained, this court shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of these courts, on the 27th day of October 2025, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. These courts, in the interest of justice, will not close its eyes to see. The court will determine all these issues in its judgments. I proceed, I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not protect
the defendant.
My Lord.
Consultant, can you tell
My Lord, I will not, please, let me finish. Please. It's my case.
I've gone.
It is my case, my Lord, let me finish. My Lord, this very court. Another idea that everyone was here, my Lord. Another idea that everyone said. And the one that we will contradict and provide no different evidence. The different evidence. I need to write my testimony to address my Lord
on the count charge which with thus.
My Lord, my Lord, I'm saying it clearly.
Defendant. Can you listen to the court? Can you listen to the court?
I need to find my family within the Constitution.
I appeal to you to comport yourself this temple of justice.
My Lord, you are there. This is not law. You are there. It's not law.
Please, I beg you to comport yourself.
My Lord, it is not law. Show me where it says you can wait my Lord.
Beg you to comport yourself.
Show me where it says you can wait my Lord to family within a place. And I put it.
You
Show me.
in the
My Lord, you have been waiting the place for them. You have been waiting the place for them. Let them show me the Constitution. Show me where it says you can wait my Lord within a place.
you have the right to appeal after my.
No, my Lord, this is your convention of the Constitution. This is not law.
Can you
It is not law.
excuse me?
My Lord, I cannot excuse.
Let him
It's not possible. It is not possible. My Lord,
take him.
you must tell me what the Constitution says. You have the right to vote on the protest. You must tell me.
Excuse him.
Show me. Show me what it says there. Show me. Show me what it says there.
Excuse him at.
Is that how you vote the president? Is that how you vote the president?
Please,
You didn't bring the president before the president today?
please,
Show me where it says you can find me on the particular. Show me.
please get the microphone from him, please.
I said, show me.
Excuse me. Get the microphone from him.
No, leave it. Leave it. Leave it. I said leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial.
Please use the microphone.
I'm under trial. Please, wait. No, listen to me. Please.
The judge must listen to me. No, wait. Wait and ask the principal question. No, wait, please.
When you have the right to waive my right to come address, show me. That's what the Constitution says. Show me.
Well, I will rise and come back.
You cannot show me.
Can you please
You cannot
take
show
him
me.
out?
Because
I will come back.
you can't show me.
I rise. I'll come back in 5 minutes.
Show me where it says you can break my right. Show me the place I'm asking you. Show me. Show me. Show me. Which law says you can try me and I'm written law? Show me. You cannot show me.